you want to build a moat, right? You want to
Hmm.
prevent competitors from being able to copy your idea. If you don't get a patent, then anyone is free to copy that idea.
Welcome to The Alternative Investor, the definitive show for investors seeking private alternative investments. Here's your host, Matt Johns.
I've always been fascinated by legal protections around intellectual property. That's why I'm so excited to share my conversation with Vincent Allen, founder and partner of Karstens, Allen & Gurley law firm. He levers his unique background with technical degrees in aviation and electrical engineering to provide clients with legal representation for their intellectual property, primarily patents. Vincent has developed a strong niche in this area. He's the creator and editor of his firm's intellectual property newsletter, The Umbrella. He's also a member of numerous esteemed legal organizations, including the College of the State Bar of Texas. And he's licensed in multiple jurisdictions, including the Federal and Fifth Circuit Courts of Appeals. Now, Vincent has a fascinating background, which you'll hear in our conversation. It was fun to get to talk a bit, too, about our alma mater, Baylor University. Not only was he the president of his law school class, but he subsequently joined the Baylor Law Review and in 2012 was named the Young Baylor Lawyer of the Year. Welcome to my conversation with Vincent Allen. I didn't realize that not only were you the president of your law class, what was that, 1999? But that you were also named the, Baylor Lawyer of the Year in 2012?
Yeah, that's right. That's right. And that was a great honor for me. I frankly was very surprised by it. I went down to it was a Baylor Lawyer event that was held in conjunction with the State Bar of Texas annual meeting down in Houston. And I went down for that, and we had an event for Baylor lawyers, and all of a sudden they announced that I, got
Oh, so
this
you didn't know.
award. I had no idea that I was going to get the award. No.
Well, Vincent, thank you so much for taking this time today and talking about patents and patent law, because this is something that's, I would argue, becoming more and more relevant as technology continues to increase and becomes more digitized. And the specialization that's required, that's something I don't understand. And something I'm hoping that we can kind of unpack today. But one thing I really want to start out asking you is about just how you understand tech, because you have a unique background. I believe your degrees are in aerospace and then electrical engineering for undergrad. And then you still use that, though, in understanding how to navigate the patent world. But then how do you do that? And then in addition to all the new technologies like AI and all the different digital stuff, how do you approach all that?
I, I think part of what drives me and has driven me since I was a toddler is my very inquisitive nature. Always wanting to understand how things work, especially if I don't know how it works. That makes me even more curious. And so it started out, 3 or 4 years old. I was tearing apart the toaster oven and tearing apart the cuckoo clock, trying to figure out, what made that bird come in and out. Yeah, and so I just maintained that curious nature throughout my childhood, growing up, and even to this day. And I grew up on a farm in Mississippi, and so we were always working on old equipment that was frequently breaking down, and we didn't have the money or time to call mechanics, and so we had to, do the work ourselves,
Interesting.
repair it in order to get the job done. And so I learned how to do that growing up, and then I decided to go into aircraft maintenance school and got my aircraft maintenance certification from the FAA. But while I was there, I really enjoyed the electrical classes. Electrical engineering is something that's pretty abstract, that you can't really see
Right.
what's going on. And so that made me even more curious, something you can't see. And so I was really fascinated by that and decided to go into electrical engineering. And then my senior year in electrical engineering school, one of my professors said, well, why don't you go to grad school, get your master's in electrical engineering, And I said, well, let me think about it. And I started looking at, well, what can an engineer do other than just go to work out of engineering school. And then I just happened to stumble across patent law on the internet and discovered that there was a big demand for electrical engineers to go into patent law.
Interesting.
And so that's how I decided to go to law school. I looked up the patent attorneys in Mississippi, and there was only one patent attorney in the whole state, and he was retired. And so I said, well, I better get out of Mississippi if I want to do patent law. And that's when I decided that Texas would be a good spot because there was a lot of technology in Texas, a whole lot of patent attorneys as well. And I ended up going to Baylor for law school, and then went into, both patent law and aviation law straight out of law school. But I think that background in both mechanical and electrical engineering and just being able to solve problems and always being inquisitive kind of helped me develop my foundation for being a good patent attorney.
Mm-hmm. Well, and it sounds like you developed a tremendous work ethic through everything you were doing growing up. And that certainly translated into today and what you're doing with the legal side of things. And
Yeah, that's right.
How do you define patent law?
Oh, well, patent law is a form of intellectual property. Intellectual property is a broad term that covers various intangible properties, such as patents being one. Patents protect inventions or new ideas. In fact, the Constitution or the founders thought it was so important that they put it into the Constitution that inventors should have the rights to a monopoly on their inventions for a limited time. So patents is a form of IP. Trademarks, which is a source identifier for particular goods or services, is another form of IP. And then copyrights is also a form of IP that protects the expression of an idea, such as books and even software code. So we in our firm is an intellectual property and technology law firm. We cover or protect clients in all aspects of IP. But one of the biggest parts of our practice is the patent practice, which involves filing patent applications that cover new discoveries, new ideas, and then, if necessary, enforcing those patents or defending against the enforcement of patents by somebody else. But a patent is essentially a limited monopoly. It gives you 20 years from the date of filing that patent application to prevent others from making, using, selling, or offering to sell that claimed invention. And so it's really about promoting the progress of science by promoting the disclosure. So we have to disclose these ideas to the patent office in a patent application, which later gets published to the public. And in exchange for that disclosure, inventors are given a limited monopoly. So my role in that is helping inventors understand the very complex nature of patent law, understanding how to draft a patent application and drafting a patent application that will adequately cover their invention, because there's a lot of variability in the quality of patent applications. Some may be worth the paper they're printed on, some not. So I think it's important, if you are looking to get patent protection, that you hire a patent attorney to help you do that. And especially in the context of software patent applications, it's even more important.
So that brings up a big question, though. Do companies need patents? And then on top of that, how do they know when they need a patent?
Yeah, well, whether you need a patent, I think, depends on whether you developed any inventions or not. But what does a patent do for you? If you are a technology company, for example, and you're developing new products, then you should be looking at whether you want to file patent applications on your invention. And in order to do that, well, let's talk about why you do that. Well, you want to build a moat around your company, right? You want to
Hmm.
prevent competitors from being able to come in and just copy your idea freely, because if you don't get a patent, then anyone is free to copy that idea. Now, they're not free to use your trademarks or to copy your protectable expression of your idea. So that's protected by trademarks and copyrights. But as far as the useful features of whatever it is you've developed, anybody can copy it. So if I come up with a new software product and it does something unique and novel that's never been done before, then you want to file your patent application to cover it, because otherwise a competitor is going to look at it, see what it does, and it's usually fairly easy to code it once they understand what has happened or what you're actually doing. And so that's why you want to file for patent protection on your invention. And was there a second part to that question I didn't answer?
Oh, I don't remember what it was either. But that leads into exactly what I want to know next, though. How do you know what's new and novel versus what's been done, and then how do you protect the actual novelty?
Part of the process when a client comes to me and they're interested in patent protection, what we try to do is understand, what is it? What is the invention that you've developed? What do you think is novel and non-obvious over what the competition is doing? And usually clients have a pretty good idea of
Mhm.
what is already out there in the marketplace, but they may not know what's already been disclosed in the form of a patent application. And so what you can do, once I understand what the invention is or what the inventor thinks the invention is, then we can do a prior art search. We can look at the patents that have already been issued, as well as patent publications. That's a patent application that hasn't yet been issued, but it's been published. So we take a look at those and we can get a good idea of what's already been done in this particular area of technology. And there may or may not be something that's similar to what the client is doing. And so that's what's called a patentability search. We can
But
do that search on behalf of the client.
how does that even work? What are you searching for?
Oh, so there's a number of different databases. There's even public databases that are available. We use a private database search tool that is very useful for doing searches. Uh, but, inventors can actually go to google.com/patents and look at various technology. I think you want to be careful about, putting in your search terms there, because, who knows what Google is doing with it.
Uh-huh.
Um, but there are ways to look at what's already been filed. And so that's what we do. We have a process for going through that, and then we prepare a report, a patentability report for the client, so they can see what we found. And a patentability search doesn't necessarily mean we've looked under every rock. It's a limited search, and so you may not see everything. I mean, there's a pretty large universe of patents and publications that are out there. But in essence, what we do is we search databases for certain keywords and certain technology areas and try to locate similar patent or patent applications.
So can you give an example maybe of how this would look for maybe a new AI company or something like that, for maybe an AI search engine?
So LLMs are not really, or AI related inventions, are not substantially different than other software related patent applications, and that's what AI is. It's software
Mhm.
now. Um, but what you would do, like we have clients, for example, that have used LLMs, and sometimes it's an off-the-shelf LLM, but they've created it, their product, in a certain way with unique algorithms that they think is novel and non-obvious in view of what's already out there. And so we would look for similar software patent applications related to that particular technology area, and then advise the client accordingly. Now, there's a lot of different areas in AI, for example, that can be protected. You may have unique data processing algorithms that you're using in order to get more accurate results from the model, because one of the big problems with ChatGPT and other models is the accuracy of the results. You get hallucinations out of
Yes.
that database, because it's based on whatever data is fed into the database. And so if you put erroneous information in there, then there's a good possibility you're at some point going to get erroneous information out. And so one of the big focuses for a lot of developers is making sure their product is accurate enough, and there's ways for doing that, and unique ways. And so that's just one aspect of AI, for example, that can be considered for protection.
Surely there are a lot of, let's just say, LLM AI models that exist. They're very similar in nature. However, they've got nuanced differences. So how would you take, is there a way that you could maybe stack patents under one umbrella or something like that, or stack different pieces of the technology that constitute one patent? I've heard that happen before, and I'm not sure I'm even saying it right, but do you understand what I'm saying?
Yeah, I think I do. So essentially, yes, you can have multiple patent applications that cover a particular technology, and like you can't patent the idea of an LLM model by itself, right? So you can't patent old technology. But if I'm combining various components of old technology into a new system that is considered both unique and non-obvious in view of what's already out there, then I'm entitled to patent protection on that. And when I file a patent application, there may be multiple aspects of my technology that I'm trying to protect. And I may end up filing a number of different patent applications on the same technology, and usually they will claim priority back to the original application, meaning that I get the same filing date for my subsequent applications. And so it's not uncommon to have 5 or 10 patents issued from a single parent patent application. You can also file what's called a continuation in part application. So if I'm developing a product and I have some new ideas that I want to add to it, then I can file a continuation in part application, adding new matter to that patent application.
One thing I do want to know, though, is when these patents are created, there's a certain value that's assigned to them. And quite honestly, it has to be for accounting purposes in some cases. But how do you assign value, or how does a company know how much their IP is worth?
Well, that's a good question, and there are experts out there who can help you, value a patent if that's, if that's something that needs to be done. Obviously, there's some patents are worth nothing because there's just no commercial application for it. It may not always be worth nothing, but if nobody's practicing the invention or has any desire to practice the invention, then that patent is going to have a very low value. If, on the other hand, I've got something that is revolutionary, like an LLM model that just came out, and I've got a patent covering that, then, that could be, worth hundreds of millions of dollars. So, but the value, I think any given company assigned to a particular patent is going to vary, but I think you have to take into account, what is it allowing you to do in terms of competition in the marketplace? Is it allowing you to keep competitors out of the marketplace? Is it allowing you to keep the price of your services or your products up higher than you would ordinarily? And generally, that's what a patent monopoly will do. It allows you to charge higher prices for a superior product.
The reason why I'm asking all this is because thinking about investing, there's a value placed on the company when it's put before investors, and they need to determine whether that value is real or not. So, in their diligence process, what should they be looking for to determine A, if the patent is legit and it actually creates that moat, and B, how is the valuation determined, or is it actually valid?
Right. So investors are going to, I'm presuming you're suggesting that the company that is looking for investments has assigned some value to the patent. And so the investors are looking to, make sure that that is in fact a valid patent that they have obtained. And and so how do you do that? Well, the best way to do that is, do appropriate due diligence. As an investor, if you have no expertise in patents or the technology at issue, I think the first thing that you would want to do is understand what the technology is. So having somebody who can help you understand it and understand what competitors are doing, I think is important. And one way to do that is to do a search called a landscape survey of the patents that already exist in that particular area, and then determine, okay, based on this prior art, how much of an improvement, or is it an improvement? Sometimes you may find that patent you don't think is valid because there's already prior art out there that reads on that particular patent. So if there's no improvement on the old technology, then that patent's not going to be worth anything. But generally, the case is that there's nothing out there exactly like what has been patented, but there may be related patents available. So in that case, you look at, well, how much of an improvement is just an incremental improvement over prior patents, and customers are not really going to care so much for that particular feature that's been added. Again, kind of lower on the scale, that is what that patent will be worth. But if on the other hand, it's revolutionary new technology, and competitors can't practice this particular technology area without infringing your patent, then that's going to have a much higher value
Mhm.
than the latter or the former. So all of that involves looking into the patent, looking at the prior art, looking at the claims of that patent to assess what the scope of the patent covers, how easy is it to design around that patent, and also, is there still a patent application pending? Because that's pretty important, I think,
Uh-huh.
for investors to know if there is a patent application still pending, then that at least gives them an opportunity to amend the claims or broaden the claim to avoid any claims of invalidity
So,
or non-infringement by competitors.
so with patent pending, what does that actually mean in a legal sense?
Patent pending doesn't give you anything per se in terms of legal rights, but it does give you a filing date, and it does give you the right to claim that I have a patent application pending. And what does that do? Well, it does provide some deterrence to would-be copycats if they know you have a patent pending on it and you could ultimately be granted a patent. Then they're going to be looking at that patent application and trying to determine, is this something that I can design around or not, or do I just want to go in a completely different direction? So it provides that deterrent effect. And then also, once the application publishes, it is possible to get a reasonable royalty once your patent grants back to the date of publication of that application.
So it does
So,
backdate.
you're right, it does backdate to the date of publication, but only if the claims remain substantially the same in the issued patent, and usually they don't. Usually there's a lot of changes that get made, so that's a big caveat. But the point being, you don't really get any rights until you actually have an issued patent, and that's the date on. I mean, that's when you can start enforcing the patent.
What does a strong IP portfolio tell you about the management themselves?
Well, I think if an investor is looking at a company that has already filed for patent applications, that means they have, in my opinion, some business savvy. They understand, why it's important to protect their invention. They're already trying to build that moat around their company, and they understand that, well, if I don't file it now, then I may lose the right to do so. So you can't wait until, 2 years down the road to file your patent application, because once that application is published or you start offering the product for sale, then you have in the US only 1 year to file your patent application. And in foreign countries, that's an absolute bar. You don't get to file a patent application if you don't file it before you publish the invention or make it public or otherwise start selling the product that's covered by your patent.
Now, how does this work internationally then? You mentioned other countries. We're talking about US patent law. How does this interact with other countries?
Yeah, so typically the way we handle international protection is we would first file a U.S. patent application, and that will give you a filing date for foreign protection too, provided that within 1 year of your U.S. application, you file an international application. We call it a PCT application. So if I file that PCT application within 1 year, then that buys me some time to enter the national stage in various countries. And at that point, I would hire my foreign agents in whatever countries I'm working on to file the application. It might be in Europe, for example. It could be in Canada, China, Japan.
But it's individually by country.
Yeah, you have to do it by country once you get to the national phase. And so you can't get, people say there's an international patent. No, there's not. There's no such thing as an international patent. Patents are territorial. I can file an international patent application, but I still have to go into the national phase for each country.
I had no idea that you had to go country by country.
Yeah, that's right. And it can get pretty expensive, when you do that. But if you've got something worth protecting, usually you're going to want to sell it internationally.
Now, if you're protecting something, though, there is the option for somebody else to try and to infringe on that patent. And you've been on the litigation side as well, from what I understand. Do you have any examples of cases where you've had to litigate against somebody's infringement on one of your client's patents? And how did you approach it?
Yeah, we've definitely filed many, patent application or patent infringement suits on patents that have been granted to our clients. There's a number in the oil and gas industry involving downhole drilling technology that we filed. We filed some simple patent infringement suits on Christmas light strings, for example, and a variety of software-related patent infringement suits that we filed as well. As far as the way you approach it, one of the big things or big differences between patent litigation versus patent prosecution is that in prosecution being the filing of a patent application, the big difference is my audience in a patent litigation matter is typically someone who is not technical,
Hmm.
who doesn't have a technical background. And so we have to distill these technical concepts down to, basic concepts that someone can understand that doesn't have this technology background. I mean, for example, in the case of electric current flow, that can be explained by analogy to a river with water flowing through the river. And, at various points, you might have restrictions that um, in the water flow that would be resistant to the water flow, similar to resistance in an electric circuit. You might have. So you really have to understand how to try to distill that down so that somebody who doesn't know about technology can understand it.
And I would imagine if you ever ended up in front of a jury, you would have to do something similar, if not even more extreme, to make it more compelling.
Yeah, exactly. And yeah, I was actually thinking about the jury, when I was talking about this.
Uh-huh.
But judges too are, many of them are not technical. There's some that have engineering degrees, like we have one here in the Northern District of Texas who has an electrical engineering degree, but those are pretty rare for judges. And so the judge and the jury alike, they need to understand how it works. And so how do we do that? Well, it's easy for engineers to just assume that people know things when it's not so obvious, right? So how can you mitigate against that? Well, I think you can explain it to non-technical people. We've got some attorneys in the firm who don't have engineering degrees. And so we can bring them in on a case and help us with the presentation so that they can give us ideas about what maybe they don't understand, and consequently work on that for the jury as well. And then, just explaining it to family members and, seeing what they think about the way it's being explained, I think is helpful as well.
I love that. You just find laypersons to go practice on.
That's
Yeah.
right. That's right.
So have you ever seen, do you have any examples that you can share of when patents were either insufficiently filed or when there were easily avoidable problems with the patent that led to problems for the company itself?
Yeah. So there's patent prosecution and patent litigation is pretty complex. And there's a lot of rules and laws that have been established over the years. And it's just not a very simple process. And so it's easy. I mean, there's replete examples of patent that in hindsight could have been drafted better, right? So what is some of the things that happen with patents? Well, I'll go back to software patents. Not that we do all kinds of patents, mechanical, chemical, biotech, you name it. We've got a lot of different technology experts in the firm. However, I go back to software quite a bit because, that's been a focus of ours recently with the AI coming on board 2 years ago. But what I would say about software patents is that they actually can be more complicated, even though the concept behind them are more simple usually. But they're more complicated because the rules and regulations governing how they get interpreted are pretty strict. So it's very important in a patent application that you describe the invention with sufficient detail that you enable the invention. In other words, somebody with skill in the art can understand how you're going to practice that invention. And then it's also super important that you draft the claims appropriately. And if they're not drafted appropriately or with the the appropriate clarity as well as enough detail, they can get invalidated later in litigation. And so it's super important not to skimp on your patent application in the first place, but a lot of times budget is an issue, and so clients are reluctant to spend what needs to be spent to draft it the way it should be drafted, and so that often leads to patents that end up being unenforceable or that get invalidated during litigation. But a lot of these issues, they're only discovered in hindsight. I mean, we've got a defendant who's going in, they're attacking your patent, they're pulling up all this prior art, and they're trying to invalidate your patent because that's one of two mechanisms for defending against the case. One is non-infringement, and B is invalidity. So that's what every defendant in every patent case does, is they try to invalidate the patent. And so there's many patents that have been invalidated over the years.
Now, do you find that one side is more likely to win, the patent holder or the challenger?
It not really. I mean, it does depend to an extent on the court where it's being litigated. Some courts are a little more patent friendly than other courts are, but even in those courts, it might be 55%. The patentee wins and 45% the challenger wins. So it's still pretty close to 50-50, and
that's good to know.
Right.
Sometimes it's really lopsided and it's really difficult to try one side or the other.
Right. Yeah. But if you don't have a patent to enforce, most cases don't go to trial. Many patent infringement claims don't necessarily even go to a lawsuit, but they provide value because A, it might be a deterrence to infringers or competitors, but then B, maybe you use it for licensing and you're making a royalty on this patent without actually litigating the patent. So they can provide value without actually having to file suit, if that makes sense.
Now, are they always 20 years?
Yeah, 20 years from the date of the filing of the original application. So if I have subsequent applications, it still goes back to my original filing date.
And there's no extension, right? I can't say I would need another 20 years or something like that, like you could with maybe a copyright or some other kinds of IP.
Well, with trademarks, you can extend the protection indefinitely. So that's the name of the company or the logo. I mean, you can protect that forever. But with patents, the only extension that's granted is if the patent office delays the prosecution of the application. So when the patent issues, they will grant a certain number of days of patent term extension. So it might be 30 days, it might be 300 days that is added to the end of that 20-year term. But that's the only exception to that rule of 20 years.
And that's why we see with like drug companies, when their drugs suddenly go from being proprietary to being open, you can get the generic drugs, right?
Right. Yeah. Generic. I mean, that's when it goes off patent, anybody's free to go and, copy that drug.
Well, that's just terrific, Vincent. Is there anything else that maybe would be informative to investors or anybody else who's looking into patents for technologies for startup companies or otherwise?
I would just say that don't gloss over it. I mean, if you do have a company that has patent protection, or maybe they don't have patent protection, I mean, you need to take that into consideration because many of these technology companies, especially startups, their most significant value is in the IP protection that they have. And if they don't have IP protection, there's a question of are they still able to get it because they haven't disclosed the invention yet, or is it too late? So you have to take that into consideration. Is a competitor going to be able to freely copy what this startup technology company is doing? And if so, how does that affect your value proposition. And then, of course, if they do have patents, making sure that you do the proper due diligence on those patents to make sure they're going to stand up, and that there's no prior art that's going to invalidate those patents. And also that the claims themselves are written broad enough that it's not easy to design around the patent.
Vincent, thank you so much for taking this time with me today. Thank you for all you're doing for all your clients. And let's keep this world spinning with more and more innovation.
Thank you very much, Matt. It was a pleasure.
We hope you have enjoyed this episode of The Alternative Investor. If you found this valuable, please be sure to like, subscribe, and share. This show is brought to you by Honey Hive Capital Partners. Visit us at honeyhivepartners.com to continue your alternative investment journey. This recording represents the views and opinions of its guests and does not reflect the views and opinions of Honey Hive Capital Partners, LLC. Nothing in this recording, nor any communications from it, should be treated as constituting financial, investment, legal, tax, or other advice of any kind, or as a recommendation to buy or sell an interest with respect to any investment. We look forward to you joining us next time.